Ladies and gentlemen, welcome back after the tea break, and we now move to the last sessions. So after looking at some of the intrinsic issues related to judicial review, we look at some of the more manageable issues. I recall about a decade ago, one of my students participated in a public demonstrations, and then after the public demonstrations, they ran into confrontation with the police, ending up with some violent confrontation, and among other people's, my students was charged with the criminal offense of obstructing the police and assaulting the police, and she came to me for help and advice. And so one of the things I asked her is, why did you do that? Why do you want to go to attack the police as such? And her reply is, because you teach us in your human rights class that the public order ordinance is probably unconstitutional. I said, yes, but I don't tell you to confront the police. If you want to challenge the police power, there are better and more civilized ways than to test the criminal law. And at the end of the day, of course, she was not charged with any offense under the public order ordinance, but by the criminal ordinance. And I always feel that a well-planned judicial review could always be planned ahead so that you get all the necessary facts to plan for a decisions where the court will be asked to address nicely and with all the evidence around. And this may not always be the case. Some well-prepared judicial review always lay the groundworks well in advance before the leave stage. And at the same time, increasingly in recent years, when judicial review is intended, or intended at least partially by the parties as an engine for social research, it's even more important that if it is intended to be a test case, then you need all the relevant factors to be there so that the court can make a pronouncement on the legal issues that you want to test. And that's partly also complicated when these days some of the test cases involve large number of applicants. The right of a boat case involving 5,000 applicants, and these will be some of the cases which involve a skillful management and also the aftermath to ensure that the principle in the test case could be able to apply to other cases. And in the right of a boat case, we learned subsequently after the 4 test case, there's another round of litigations to argue who would be benefited from those cases, particular people who have not yet filed litigations, but in the similar situation and so on. So in these sessions, we will look at some of these issues. We have another a distinguished panel at these sessions. On my far left, and nowhere be a leftist, but it's Professor Dame Hazel Genn, a good friend of mine. And Hazel is the Dean of the Law School of UCL, and she's known as the leading academics and authority on civil procedure and a lot of empirical research on administration of justice. Her list of distinction is so long that we can spend the whole evening just to read out her distinctions. Among other things, she is a fellow of the British Academy. She has received honorary doctorate degrees from many universities. She has been on the judicial study boards for over 12 years, and particularly for the universities, she has been the chair of the UK Humanity Panels in the last RAE, and indeed in that capacity, or with that experience, Hazel has been helping us with our own tedious RAE exercise. And to my immediate left is Dr. Alex Mill. Alex is a senior lecturer of UCL and also part of the delegate of UCL. I think this is your first time in Hong Kong, so welcome very much. And Alex has a distinguished academic background from Sydney and then from Cambridge, where he did his master and PhD. And among his other distinctions, he was awarded the American Society of International Law's inaugural Private International Law Prize. And he works in a full range of public and private international law issues. And to my right, and which probably people regard him as a leftist or rightist or whatever, is Mark Daly, a well-known solicitor in Hong Kong. And Mark has been the instructing solicitor of many judicial review cases, and he has a wealth of experience in handling multi-party, well-designed judicial review cases, etc. And glad that Mark is going to share with us his experience in the Hong Kong context. So according to program, if I ask Mark to kick off the discussions.
Thanks, Johannes. I'll try to suffer through a little bit of a flu, so I'm going to see if I can get through this today. Monday, 25th of March, 2013, a little over a year ago, was a significant day for us, marking the culmination of 2 series of test cases that made their way through the Hong Kong legal system to the Court of Final Appeal. The 2 cases serve as examples of test case litigation and highlight maybe some of the lessons learned and shed some light on some of the themes of this conference. A large press scrum gathered to hear the result of the migrant domestic workers' fight to be treated as any other foreign worker and to be able to apply for permanent residence as set out in the basic law. The judgment on that morning was to be handed down at 10 a.m. The case of C and others, and on whether there is a duty on the Hong Kong SAR to screen claimants and decide if they met the definition of refugee, independently of the UNHCR, was to be handed down 1 hour later at 11 a.m. Now the scene, arriving at the Court of Final Appeal, outside the entrance, it was packed with journalists. I hadn't seen a scrum like that. The only other time I think was in Malaysia for the opening of the Anwar Ibrahim trial, and I was there for Amnesty International. That was the last time I saw a group as large as that. There's very little lead time from finding out that the judgment will be handed down. It was a Monday, and you'll find out Friday afternoon that the 2 judgments are going to be handed down. And certainly for our clients and for our firm and the legal teams, a lot of emotions and stress involved. You're thinking about, first and foremost, your professional obligations and your clients and the client's expectations, but then the wider public interest. You're continuing to fight. You're thinking win or lose. It's an opportunity to continue the struggle for justice, and the emotions of living with a series of cases for at least 7 years in the case of the domestic workers and 6 years for the group of cases involved in C and others. And I must add a little bit of, more than a little bit of frustration and irritation that the Court of Final Appeal decided to hand them down 1 hour apart. You don't get a chance to really reflect and probably do as good a job on either in terms of public education and what the cases mean and trying to disseminate a message. So we're a little frustrated by that. There was also a little bit of a tease. I've reported in the South China Morning Post. Some of these things coming back to me, for a year I really haven't wanted to look at the judgment again. Didn't want to read the Vallejos and Domingo judgment, so I've had to do that in preparation for this conference. And some of these things, I'm reminding myself of some of these things that on the 23rd, 2 days before the judgment came out, Chief Justice Geoffrey Ma was quoted as saying in the South China Morning Post, "Popular opinion will never sway the judiciary," says Ma. Popular opinion won't sway the judiciary. No regard will be paid to whether the result will or will not be a popular one. Certainly not to whether it will accord with what the majority of the community wishes. So we had that. I think he was speaking at Chinese University on the Friday, and that was reported on the Saturday before the big Monday. So you can imagine us sitting in our firm and thinking, is he teasing us? Is he softening up the public because we won? And so a lot of emotions going on there. I won't go through the details of the case. I'm not going to go through the merits at all. Everybody knows what happened. The Vallejos and Domingo test cases we lost. The Court of Final Appeal, in my view, failing to uphold the law and do justice in the cases, was crushingly disappointing. And outside the court, I think the best statement was made by the NGOs who were helpful in following along with the cases. that it was in I think they say the judicial seal on social exclusion, and that was and I think reflecting upon that is really important when you consider the role of judicial review and the judiciary in these cases. That encapsulates many ideas about what certainly the domestic workers thought about this this result, and I think a lot of the media around the world thought of this case. As far as lessons go on this case, it brought out certainly an ugly side of the Hong Kong SAR. Ignorance, discrimination, and I have to say fostered by the Hong Kong SAR government. Remember that the government in this case somehow produced an affirmation or two showing the doomsday scenario if we were to win. Just prior to the hearing and upon our saying that we would want to see the data and how they came to these numbers, cross-examine them on such evidence, they withdrew it. They withdrew reliance on the affirmation, but the exaggerated numbers had made their way into the media and were taken as a given the rest of the way. And I brought along the affirmation that we had produced after that by Professor Paul Yip, whose credentials are quite stellar, and on reflection, again, lessons from these big test cases. I never expected that the media would not ask more questions. The 400 to 500,000 number that came out in the press, we, at every press scrum, tried to get out some of the detail of what, I'll read a little bit of it. Excuse me for a second. So the affirmation sets out Mr. Yip's background, PhD in biostatistics from La Trobe University, and his initial view upon looking at the government affirmations, his view that the conclusions arrived at by the first respondent are unrealistic and tainted by data that is crude and unreliable, methodology that is crude and biased, and assumptions that are not supported by available information. I further note that the second affirmation of Ms. Wong, the government affirmation, has been withdrawn after a letter from the solicitors for the applicant seeking production of the said data and materials. But again, the numbers had gone viral, and again, I think I've mentioned before that a large part of the exaggeration was the so-called dependence of the domestic helpers that would have all, on the government numbers, all been allowed to come immediately to Hong Kong, which is complete garbage. And Ms. Vallejos, the test case that made it to the Court of Final Appeal, was the perfect example. She had 5 children, and none of them would have qualified under the dependent visa policy, not to mention the fact that none of them wanted to come here in the first place. So the government wildly exaggerated these numbers, and first question is certainly, is that a responsible government that does that, basically sows seeds of discontent, and basically exaggerates these things and the discrimination against the domestic helpers. So certainly that was, and the fact that we couldn't get that message out in the media was a surprise to us. Generally, the media has, on a lot of our cases, been quite good, but on this case there was a definite shift, and they did not want to get out a contrary message. Other things that we learned from this litigation, aside from normal litigation issues, Johannes mentioned, choosing cases. You have to have a certain volume of cases in order to help you best choose the test cases. The government is always in the driver's seat. They can see all the cases coming through the system, and they can always offer settlement. Even in this case, not too many will remember that Daniel Domingo, he was offered unconditional stay. So basically, at the early stage, he was offered, don't forget your constitutional rights. We'll give you unconditional stay, take you off a domestic helper contract if you go away. But he didn't, and we continued with the litigation. And this was, again, the test case was chosen because Mr. Domingo and Mrs. Domingo were on domestic helper contracts. Their children were permanent residents. They were born here and they became permanent residents. So again, you're trying to choose test cases. You want to squarely attack the issue of what we saw as an unconstitutional provision of the immigration ordinance that says domestic helpers can't apply to be permanent residents. You also have to consider when you're setting up these test cases the work involved. Remember that legal aid's only available for the in a case like this for the court of first instance for the judicial review, but there's 2 or 3 years of work through the tribunals, and more than these 2 test cases. There was half a dozen or about 10 of them that we had to work with through the tribunal stages, with publicly spirited barristers joining our teams to work through the court. So the fact that this even went to the Court of Final Appeal was a miracle, and I'll get to it. Is that with the way things are going, there may be difficulties in these cases getting to the Court of Final Appeal in the future. Now, enough of the complete doom and gloom. At 11 o'clock, the C case, we won, and there's no press scrum. They were already packing up all their cameras, and it was quite remarkable to see. They were all gone, and we came out at 11 with a victory in the refugee case, and had to beg to have a couple of them stay behind so that they could get a little bit of the story out. It's a little not surprising, but for Hong Kong, the domestic helper case was really the big news for a long time. But from a standpoint kind of international law, the refugee case, the domestic helper case was unique really to Hong Kong and the basic law, and the case, the refugee case of C is being watched by experts in the area around the world. Anyway, I think there was a little piece in the South China Morning Post. We won that case. That the origins of the win really went back to Prabhakar and those who I won't have time to go through the history of that, because the chronological build-up to the case of C was such that the wider consequences from C really didn't have that big an impact. We had already won Prabhakar, we had already won the cases before, meaning that the Hong Kong government had to set up the system called the USM system now anyway, and so C really wouldn't have the wide impact or even the perceived wide impact that we would have had if we won the domestic helper case. So as far as to stick to judicial review for social change, a huge success story. I think C was just the exclamation point on a number of cases that has basically resulted in a system, a non-refoulement system in the Hong Kong SAR that was driven by a series of judicial reviews, and I'm certainly personally very proud of how that worked out, and the fact that now there are 400 lawyers on the duty lawyer panel who otherwise would not be getting training in refugee human rights law, not to mention the Torture Claim Appeal Board and everything else that has been set up as a result of judicial reviews. So as far as tangible results, education, all of those things, those have come through those series of judicial reviews. Just to end off, I mean, what's on the horizon, I think we still have to remember the limits of judicial review, the delay in setting up this USM system, and the fact that we've got stagnant governments, no vision, no leadership, and the fact that it's reactive, and the USM system should have been set up 10 years ago. We won Prabhakar in 2004, and any forward-thinking government would have set up the system at that time. But we're 10 years on, waiting for a series of judicial reviews for the judiciary to tell them what to do. Obviously, the clients and the asylum seekers and the torture claimants all get hurt in the process because there's this endless limbo having no system. And recently, where do we go in the future? Just last week, the statistics came out on judicial review. Many would have seen it, but record few given their day in court. And this accords certainly with our experience, our firm's experience. Government data revealing that the proportion granted leave to launch judicial review hit an all-time low last year, despite a 10-year high of applications. So, and you know, we obviously want to see the details of those statistics, but certainly I can say our firm and a lot of the working with very experienced counsel in the area, we don't take bad judicial reviews, but they're still having a lot of difficulty now even getting leave, and some of the problems that have been alluded to earlier on in the conference. Future, we've got with the Court of Final Appeal, traditionally we've looked to you know, getting through the trenches to the Court of Final Appeal and thought that we would have light at the end of the tunnel, because the chances of success were often higher at the Court of Final Appeal. I think that now is a question mark, and I think you know we're going to see how that goes. I mean, they're turning the taps off at the in order to get into the Court of First Instance and to get leave, and I think it's a question mark whether there is any light at the end of the tunnel. And perhaps I'll leave it there for now and look forward to questions.
Thank you, Mark. And then we turn to Alex on the UK experience.
Thank you very much, and thank you very much for the opportunity to be here today and to participate in this conference, to Professor Chan and to all the conference organizers. So the title of this session is Beyond Traditional Judicial Review. My focus is on a different aspect of the subtitle, on public interest litigation, and I'm going to focus on some particular reform proposals and debates which are going on in the UK today on this question. So the traditional and still the most common scenario for judicial review is where you have a party who's been directly harmed through what they believe to be an unlawful exercise of public power. For example, wrongfully refused a license by a government department, and they bring proceedings to challenge that exercise of power. In this traditional form, judicial review combines two elements. First, protecting a private right, and second, righting a public wrong. But of course, there are other government decisions which might affect a small or large group of people rather than an individual, or benefit one individual or group, but negatively impact on society as a whole. Government decisions might affect individuals outside the legal system and without access to its courts. There may even be policy decisions which don't have an impact on any individual at all, at least not immediately. These types of decisions raise an important issue, which has recently, and I think slightly surprisingly, re-emerged for debate in the United Kingdom. To what extent does judicial review require a private right, and to what extent does it only require a public wrong? To what extent is judicial review about protecting individuals from an unlawful exercise of power which causes them harm? And to what extent should it serve the public function of ensuring that power is exercised lawfully in defense of the rule of law? Part of the reason this issue is difficult is that, as we all know and as the courts have long recognized, the public interest of ensuring the lawful exercise of power must be weighed against the very real possibility that judicial review might unduly affect the efficiency and effectiveness of government decision-making, which is also an important public interest. My paper examines these issues through a focus on a very recent 2013 to 2014 public consultation carried out by the UK government on the possibility of reforming the law of standing in judicial review, as well as related issues concerning the costs of judicial review and third-party interventions in judicial review proceedings. In my presentation today, I'm going to focus on 4 points. First, the existing approach to standing under English law, as well as certain aspects of the rules concerning the allocation of costs in judicial review. Second, the reform proposals put forward by the UK government in September 2013. Third, a response to those proposals which was submitted by the senior judiciary. And fourth, the UK government's own subsequent response in February 2014, which is partly reflected in the Criminal Justice and Courts Bill of 2014, which is presently before Parliament in the UK. So in deciding whether or not to grant a remedy on the merits of the case, the question of what a sufficient interest means for the purpose of this test came before the House of Lords in the National Federation of Self-Employed and Small Businesses case of 1982, which is still the basis of the modern law. The Lords were all agreed that it was not necessary for an applicant to have a specific private right, which was affected by the decision, in order to establish a sufficient interest. This had been a requirement in some cases before the statutory test was adopted. On the other hand, there was general agreement that a mere busybody does not have a sufficient interest. But the court was less clear on where the line should be drawn between these two extremes. Essentially, the answer given by the majority and the approach followed by the courts in later cases was that the test of standing is variable. For government decisions which are directed at a narrow range of affected interests, the court will be unlikely to intervene without the applicant having a direct stake in the proceedings. But for issues of great importance and public concern, a much less strict test of standing will be applied. In the Lord Rees-Mogg case in 1994, for example, the court permitted a challenge to be brought by an individual member of Parliament concerning the UK ratification of the Maastricht Treaty on European Union, accepting the applicant's standing on the basis that, quote, "We accept without question that Lord Rees-Mogg brings the proceedings because of his sincere concern for constitutional issues." For public interest cases, the initial gateway question of the applicant's standing has thus, at least arguably, become little more than a good faith test, asking only whether the application is brought sincerely and raises a serious legal issue. In cases in which there's no private party who's been directly affected by a decision and who is capable of bringing proceedings, the courts have been particularly flexible in their approach to standing. Movement case in 1995, for example, proceedings were brought to challenge a decision by the Foreign Secretary to provide aid for the construction of the controversial Pergau Dam project in Malaysia. The applicant in this case was a charitable company established for the purpose of campaigning and lobbying to improve British aid to other countries. The court noted a range of relevant considerations, including the importance of vindicating the rule of law, the likely absence of any other responsible challenger, as well as the expertise of the applicant in the development of aid policy. The court thus effectively developed sort of a collective public law extension of the principle of access to justice. In the absence of any directly interested party, others had to be afforded standing to ensure access to the rule of law. On the basis of these factors, the court held that the requirements for standing were satisfied in this case. And a similar approach has been taken in a number of subsequent cases, and the accepted modern position is that standing is not necessarily limited by any conception of private rights, particularly where the matter concerned is a matter of public interest because of the important public function of judicial review. Where a government decision affects matters of public interest, it's now unremarkable to see claims brought by an incorporated or unincorporated association established by a group, or even sometimes by a sincerely concerned individual whose traditional sole means of complaint may have been writing a stern letter to the editors of the Times newspaper. It's been increasingly also recognized that the issue of costs for judicial review proceedings may also have an important impact on the balance struck between efficient governmental decision-making and protecting the rule of law. To oversimplify a little, typically in judicial review, the losing party pays at least part of the costs of both parties. An obvious concern is that the potential for cost liability if the claim fails might stop an applicant from bringing proceedings at all against a wrongful government decision, and thus limit the effectiveness of judicial review in giving effect to the rule of law. On the other hand, the possibility of an adverse costs order may legitimately function as a disincentive for an applicant with only a weak case from proceeding with their application. The balance struck between these interests has arguably been affected by two recent developments. First, as mentioned by Lord Carnwath this morning, the courts have developed a practice of making a protective costs order in certain cases, capping the maximum potential cost exposure of an applicant should their claim fail, with the idea that this will encourage proceedings brought in the public interest. The court held in the Corner House research case in 2005, which first developed these orders, that this new approach to costs was required because there is a public interest in the elucidation of public law by the higher courts, in addition to the interests of the individual parties. Second, as I've already discussed, it's become accepted that proceedings may be brought by an association, incorporated or otherwise. The association might be a limited liability company, which could limit the potential liability of the members of the association for costs orders which could be made should the claim fail, and thus increase the risk of speculative claims. To put this another way, if a limited liability organization established by a campaign group brings judicial review proceedings, it's potentially itself awarding its members a PCO, capping their risks of potential cost liability. Alternatively, such an organization may be set up with limited assets and so actually apply for a PCO, even though it's funded by individuals who have much greater resources and would not be entitled to a PCO if they were bringing the proceedings directly. In September 2013, the UK Ministry of Justice published a paper entitled Judicial Review Proposal for Further Reform and invited submissions in response. In relation to the issue of standing, the report suggested, and I quote, that too wide an approach is taken to who may bring a claim, allowing judicial reviews to be brought by individuals or groups without a direct and tangible interest in the subject matter to which the claim relates, sometimes for reasons only of publicity or to cause delay. This somewhat surprising argument conflates two separate questions: the degree of personal interest of the applicant and the genuineness of their claim. It's not entirely clear why individuals without a direct or tangible interest are more likely to bring unmeritorious claims than those with such an interest. Indeed, the statistics cited by the report itself suggest that the opposite is true. Judicial review applications brought by parties without a direct personal interest have tended to be more successful than claims brought by parties with a personal interest. Nevertheless, the report suggested the possibility of narrowing the test for standing to require a more direct and tangible interest in the matter to which the application for judicial review relates. The report also raised a concern with awarding protective costs orders, PCOs, in the context of judicial review. Again, to quote, "The government is concerned with the use of judicial review as a campaign tool. The government questions whether it is right for the public body defendant to be required to fund its own costs of defending that case if the claim fails." Now, it's true that PCOs may reduce the disincentive to bring a weak case for judicial review, which would normally be provided by the risk of an adverse costs order. The report suggested that political and campaigning judicial review claims should therefore not be given cost protection. But it's not clear, at least not clear to me, what political or campaigning are supposed to mean in this context. If they're intended to refer to unmeritorious claims brought solely for publicity, then it's unclear why these concerns aren't adequately dealt with through the process of requiring leave to bring judicial review or the discretionary test for the award of a PCO. Finally, the report also noted the possible risk arising out of the fact that the courts have permitted representative bodies, including limited liability companies, to bring claims. On this issue, the government asked for views on whether to amend the requirement to provide information on how litigation is funded and on the power to award costs against non-parties. The consultation launched by the government received 325 responses from a variety of individuals and public and private organizations. I'm just going to focus on the response presented by various members of the senior judiciary after consultation with other members of the judiciary. The judicial submission addressed the issue of standing in judicial review, emphasizing that, to quote, "Judicial review constitutes a safeguard which is essential for the rule of law. It ensures that public authorities are accountable and act lawfully." Taking up this theme, the submission defended the existing legal position and argued that narrowing the rule of standing posed a threat to the rule of law. To quote again, "Unlawful use of executive power should not persist because of the absence of an available challenger with a sufficient interest. We do not agree with the suggestion that standing should be limited in some way to those with a direct interest in the subject matter." End quote. On the issue of protective costs orders, the judicial submission was equally forceful. In response to the report's suggestion that PCOs may distort the balance of incentives in judicial review proceedings and thereby encourage unmeritorious proceedings to be brought, the submission argued that PCOs function to protect access to justice and that the existing rules already strike a balance between the various interests at stake. The judicial submission did, however, straightforwardly support the proposal that it should be mandatory for a claimant to provide details of how a case is funded in order to assist the court when determining whether to make a PCO. In early February 2014, so just a couple of months ago, the UK government published its own response to the submissions made under the consultation. The decisions on reform are essentially reflected in the Criminal Justice and Courts Bill of 2014, which is currently before Parliament, which also deals with a range of matters unrelated to judicial review. The government response noted, perhaps not entirely without a hint of irritation, that the reforms which it had suggested were largely opposed by the submissions it had received on various grounds. Some respondents had argued, for example, that, to quote, "a direct interest challenge for standing would alter the purpose of judicial review, moving the focus from challenging public wrongs to protecting private rights." On the issue of standing, there are indeed, finally, no reforms proposed to the existing law. The reform proposals focus instead on the costs issues, which I've discussed. For example, the Criminal Justice and Courts Bill proposes to codify the rules governing the award of protective costs orders and thereby constrain the circumstances in which a PCO is available. Perhaps the most significant proposed change is that a PCO may not be awarded until after leave to bring judicial review proceedings has been granted. This would mean that an applicant bear the risk of adverse costs for the initial leave application. It's not clear whether this is a necessary or desirable rule. A further provision in the Criminal Justice and Courts Bill provides that an applicant who benefits from a PCO must also be subject to one, so that a public authority found to be acting wrongfully will not necessarily be liable for the full costs of the applicant, even if review is granted in favor of the applicant. Now, it's far from clear why public authorities require the same protection as those which are offered to applicants, who would not, without such protections, proceed with their application. The government's response suggests that this rule is aimed at, to quote, "ensuring that the taxpayer has cost protection to ensure that costs overall remain within reasonable limits," end quote. but surely the taxpayer's greater interest is in compliance with the rule of law. The proposed rule, if adopted, would have to be applied very carefully indeed by the courts. If the limits on an applicant's ability to recover their costs are set at a level below the costs of raising all the potentially relevant arguments, the effect is likely to be that issues are not raised which should be brought before the courts. And one wonders how a judge is supposed to determine these questions in advance of hearing argument on the merits. Finally, as already noted, the judicial submission supported the idea that applicants should be required to provide information concerning the financing of their application. These measures are also reflected in the Criminal Justice and Courts Bill, and they seem unobjectionable, even if it has not been established that they address a genuine problem in practice. So, to conclude, I'd like to highlight three particular features of this story. First of all, the UK government proposal to restrict the rules of standing in judicial review provoked a strong response and has clearly been dropped. The possibility of public interest proceedings, including those brought by representative or interest groups, remains an important part of the UK's constitutional landscape in support of the principles of access to justice and the rule of law. A second point which I think deserves highlighting is the importance and complexity of costs issues in judicial review. The potential for an adverse costs order against an unsuccessful applicant is at least partly designed to limit interference with the exercise of public power. This risk might, however, be an obstacle to some applicants with meritorious claims, leaving unlawful decisions unchallenged, an issue which has been properly dealt with by the courts through the practice of awarding protective costs orders. But it is true that such orders might themselves lead to some applicants increasing the costs of judicial review because they're no longer subject to the full risks of bearing the public authorities' costs should they lose. The complexity of these issues perhaps suggests the need for a flexible approach, striking a balance in each case between the interests of each party and the public interest. My final point, and perhaps the point of most general interest of these recent developments, is that it's striking to observe the exchange of views which has effectively taken place between the different branches of government. Through the UK Ministry of Justice report, the judicial submission, and the government's own response. It might seem curious to see such matters of fundamental constitutional importance being debated by the judiciary and the executive, essentially in a public forum. But this may be a necessary and in many ways preferable advance on the days when the views of the judiciary were represented informally by the Lord Chancellor in the secrecy of cabinet meetings. The judicial function of restraining the improper exercise of public power through judicial review in support of the rule of law seems to have been extended to publicly opposing reform measures which would enhance executive power at the cost of limiting the rule of law. The judiciary, it seems, are no longer only defenders of the rule of law in the courtroom, but also as a matter of public debate, perhaps even in the courtroom of public opinion. This is, however, perhaps simply part of the dynamic and in many ways strongly political nature of the constitutional settlement in the United Kingdom. A constitution which is constantly in the process of debate and negotiation, striving to combine the stability of centuries of tradition with a dynamic attention to important and evolving questions of constitutional balance.
Thank you, Alex, for this wonderful presentation on recent development in UK. Just a quick remark is that in Hong Kong, there were a few unsuccessful attempts to obtain a protective court order. The court in Hong Kong has never been keen, but on the other hand, the court is more willing to grant an indemnity court order after the event. And indeed, in the leading case from the Court of Final Appeal on the harbour reclamations, the principles laid down in order to obtain an indemnity court order in a public interest litigation. One of the criteria is the parties should have no direct personal interest in the matter. So it's precisely reflect what the judiciary said in UK. So I'm sure this is an interesting development. Now, in recent years, the government has been pushing mediation as an alternative dispute resolutions. While this has achieved quite something in the area of private and commercial law, a lot of people are very skeptical whether mediation could work in public law, and in most cases when people are contemplating judicial review, there's probably no rooms for any further mediations, and especially in these areas when it is the legal principles which matters rather than a matter of compensation. So we can't have a better expert than Hazel to talk about mediation. So Hazel's your floor.
Thank you very much. I have to say I was a little bit bemused when you asked me to talk about mediation in judicial review. A, because I'm a well-known mediation skeptic, and secondly, because I'm not an expert in judicial review, so obviously nobody better to talk about it. I told somebody before I left London that I was coming to talk about mediation in public law, and they said, well, that won't take you very long, will it? So I won't detain you for too long this afternoon. In fact, we have remarkably little experience of use of mediation in public law. And we've got even less evidence, I think, so we've collected even less data about it, and I'm going to depend very heavily on one research project that's been done. But anyway, so what I want to do in the time that I've got available to me, is to talk about what mediation is, to say something about the benefits, the assumed benefits of its use, and to think about whether or not JR is different, and if so, in what ways. So what I put on this slide, first of all, what is mediation? We need to remind ourselves about some of the central features of mediation so as to think about it in relation to judicial review. So it is generally assumed to be a voluntary process, although the government in the UK has been trying to make it mandatory in some fields. It is basically facilitated settlement with the assistance of an independent and presumably neutral mediator. Mediation tends to focus on problem solving rather than on the legal merits of the case, so you have no determination on merits, and most classic mediation is facilitative, oh, never mind. It's the end of a long day. Facilitative mediation, in which you don't have evaluation and you have no determination or even discussion of merits. It is a confidential process, which I will come back to later on, and the outcome of mediation need not be fair. I always say this, but I have to stress this, that the responsibility on a mediator in a normal mediation is to achieve a settlement. They have no responsibility to see that the settlement is fair in the context of people's legal rights. It is simply to achieve a settlement that people can live with. And so I always say that mediation is not about just settlement, it's just about settlement. And in the context of JR, one has to bear that in mind. Mediation, what mediators talk about, and I know that there some have come into the room, and so they can argue with me later, but the essential focus in mediation is on communication, on repairing relationships. It's on where you're doing commercial mediation. It's on the commercial realities of a dispute. What the focus is not on is anything to do with the legal merits of the case. And when mediators talk about the benefits of mediation, the focus is very much on it being cheap, it being quick, it being confidential, and capable of more creative outcomes than are possible in court. Now, all of these asserted benefits are benefits that are set up in contrast to assumptions about what happens at trial. So it's cheaper than trial, quicker than trial, obviously confidential, and possibly more creative. And I would say that in the JR context, what I'll go on to say is that some of those things are actually not borne out. The confidentiality is actually a positive disadvantage. And actually, for people in certain circumstances, going through trial and receiving a legal determination is actually an empowering experience, not a traumatic experience. In the UK, mediation is most commonly used for commercial disputes, disputes between neighbours. There's been a growth in the use of mediation in employment disputes, often very successfully, I think. A lot of use in family disputes, and a heavy government emphasis at the moment on compelling people to mediate family disputes. It's also used to some extent in the criminal justice system in a restorative justice context where we have a degree of victim-offender mediation. So we do have quite a lot of experience of the use of mediation in a range of disputes and a range of circumstances. The question is, if we are contemplating the use of mediation for JR or for public law disputes, is there something different about JR that should give us pause for concern? Well, at the end of a long day, when we've been talking about JR, public law, the rule of law, obviously there are some very important aspects of JR that should give us pause for concern. First of all, the constitutional function, checking the decision-making of government. It's a critical check on the power of the state. We are checking decisions, we're checking actions, and we're checking omissions. So hugely important constitutional function. And more recently, and we discussed this a bit in fact, Lord Carnwath discussed this in his lecture at the beginning, that actually increasingly we are using it to test human rights compatibility. And we heard a lot about that this morning. The other thing to say, however, and that is part of the context for thinking about what value mediation could provide for JR cases, is that actually in the UK there is a very effective filtering system. So a very high proportion of JR actions or potential JR actions are settled even before the issue of proceedings. 60% of permission applications are actually refused, so a very high level of refusal. That means that those cases that go beyond the application stage, it's a very small minority, and only 5% of cases actually go to a substantive hearing. So query, is it so important that that the government and that to some extent some of the judiciary should be pushing to have mediation in that small proportion of cases that are likely to go to a substantive hearing. I think the other thing which I didn't put on the slide but which is important is that actually judicial review cases proceed much more quickly than a wide range of other cases. So one of the arguments in favour of mediation in other contexts is that it's going to be quicker than a case going to trial. JR cases are usually dealt with very quickly, and so the need for speed or the argument about speed that mediation could provide, I think, doesn't stand up in that context. Despite the fact that there are these different characteristics of JR, that you have these constitutional issues, these rights issues, the government and to some extent the judiciary have been putting some pressure on to use ADR in JR. I would say it started in the mid to late 1990s, and I think it started with the Wolf reforms of the civil justice system. The Wolf reforms had a huge emphasis on settlement and on the use of ADR. The government has never been that fond of judicial review, and to some extent they've been following along from the emphasis and some of the rhetoric of the Wolf reforms in relation to the promotion of ADR and the preference for ADR over legal determinations. In fact, I did remember that I am a slight expert in this, that after the Wolf reforms, I actually sat on a working group that was established in the Royal Courts of Justice to consider how it would be possible to promote the use of ADR in judicial review. My recollection is that we didn't conclude very much, so it wasn't a very successful working group. However, Lord Wolf was trailing a blaze or blazing a trail in this respect, as he has done in so many other respects. The case of Cowell and Plymouth City Council, which you may know, in 2001, he reflected on the use of ADR, and he said, "Today sufficient should be known about ADR to make the failure to adopt it, in particular where public money was involved, indispensable." So quite a strong statement there. As I say, the government has also been promoting it. Part of the Wolf reforms was the publication of a large number of pre-action protocols. There is a judicial review pre-action protocol, and in its current formulation, there is a whole section in the Judicial Review Pre-Action Protocol on ADR, and these are the essential elements there. Parties are to consider whether ADR is more suitable than litigation. The court can require parties to show that ADR has been considered. There should be no issue of proceedings where settlement is possible. They include within ADR processes discussion and negotiation, ombudsman, early neutral evaluation, and mediation. But the sentence in yellow shows that even in this pre-action protocol, there is a recognition of the different status of JR, because the government and the judiciary have been promoting mandatory mediation for almost every sort of dispute. But here in the Judicial Review Pre-Action Protocol, it says it is expressly recognised that no party can or should be forced to mediate or enter into any form of ADR. So what you've got here is quite a strong exhortation to people to consider it, but certainly no grounds for forcing people to do so. As I said at the beginning, there is only one piece of research evidence that I know of and that I've come across in my research for this presentation today on the use of ADR in judicial review proceedings. That's a report carried out by the Public Law Project in London. They interviewed parties and solicitors who had been, and barristers who had been involved in some ADR in judicial review cases. And I'm picking up now on some of the things that emerged from that research. First of all, significant concerns about the use of mediation in judicial review cases. The argument is that for most cases there is no room for compromise, so how would you be mediating? Major concerns about power imbalances, the imbalance between the citizen and the state. The fact that there is a public interest in precedents. I believe there's a public interest in precedents, not just in judicial review, but in common law systems. You need precedents for the elaboration and development of the law. The other concern and interesting empirical fact that emerged is actually in judicial review proceedings, mediation may not be less expensive than judicial review, but actually may be more expensive, and also the assumption that it wouldn't work for urgent cases. Within the research report, there's discussion about the use of attempt to use mediation in sex discrimination cases, and there's a discussion about the fact that ADR raises issues of privacy, it raises issues of power imbalances, and it raises issues about the lack of attention to legal rights. All of the things that I've spoken about before. And there's the issue of publicity, very important. Public hearings can be an important source of information about legislation. People are reminded of its existence and able to see its working. This is the public value of courts, and we should not underestimate the public value of courts in the communication of norms, in the promotion of legislation to assist and develop social justice. The authors of this research report were trying to come up with some guidance about how to assess which kinds of cases in the public law sphere would be particularly appropriate for ADR. And they said, actually, it's impossible to say. What it is easy to say is which kinds of cases are definitely unsuitable for using ADR processes. The kinds of cases that were deemed to be unsuitable are cases where a declaratory function is required, where you're dealing with ultra vires, where there's a point of law that needs to be decided, cases raising public interest issues, and also where there's an issue to do with vindication of rights. I'm not sure what that leaves behind after that lot, but certainly those are the cases that were deemed to be particularly unsuitable. But having said that, it is clear, and there are examples where mediation has been used quite successfully, where there are certain kinds of cases where individuals will bring an action for judicial review over a complex issue that is capable of negotiation. And the kinds of areas where it has been successfully used, the examples given are cases to do with things like special educational needs provision, care provision in relation to people with disabilities, disputes over the responsibility of local authorities to make provision for people with disabilities or to make provision for children needing special, who have special educational needs. In those situations, there are examples where it's been possible, following the issue of proceedings for judicial review, for the parties to sit down together and to hammer out some kind of agreement. And there is evidence that in some of those cases, the kinds of agreements that have been produced have been probably more creative and actually more constructive than might have been the case if they'd gone to court. There are also cases involving asylum issues and licensing issues that have been mediated successfully. So I don't want to give the impression that it is impossible, but one has to be careful what kinds of cases it would be suitable and how a creative settlement could be achieved. However, the benefits, the empirical data in terms of the benefits of mediation raise some questions. So on the issue of speed and cost, no evidence that actually mediating JR cases is any cheaper or any quicker than a judicial review hearing. So few gains in terms of cost or speed, some gains in terms of flexibility and creativity, and some evidence of gains in terms of relationship repair, where a relationship is actually important in that particular context. A small footnote, a suggestion of ways in which mediation could possibly be promoted in JR cases is through the use of what's known as rights-based mediation. There is the concept of rights-based mediation in which there can be a recognition of rights in negotiation, where you can have a settlement that can include recognition of rights, or in fact could include a public apology of some kind of breach. The parties could also agree to having the settlement publicised, so there could be an agreement about publicity, and the settlement could include a modification or an adoption of some sort of policy procedure, some policy or procedure. I have to say that nothing has been written about this since the early 1990s, so there hasn't been much of a development of rights-based mediation, and I could find no examples of its use in JR cases. And even among those people who think about the possibility of rights-based mediation, they raise legitimate concerns, the fear that justice will be made subordinate to administrative efficiency, and that reforming legislation, or the radical force of reforming legislation, will be tamed by, I love this term, subterranean resolution. I'm going to use that in the future. That basically obscures the essential value, the essential question of the value of having public determination of legal rights. So to conclude, as I said, there is limited research evidence about the use or value of mediation in JR cases. It is clear from the limited amount of evidence that there is, it's clear that it's not cheaper in most JR cases, and it's not quicker. It may be slightly more creative, but if it's more expensive and slower, is there any huge advantage? And there's a question raised about if the government recognised that mediation was neither cheaper nor quicker, would they necessarily be promoting it? Well, I think that they might be promoting it, and I think that, and the reason why I think that government might continue to promote it goes back to this question of publicity, and this is the handshake. I had another one which I've got rid of, which is actually, instead of a handshake in this context, actually the image I should have left you with is an arm wrestle. And it's an arm wrestle with a much bigger, I did find one, but then I didn't use it in the end, of a very large muscular arm against a much smaller muscular arm. And I think that, I think there are, the questions that we should be asking are not how can we divert cases off into private mediation, subterranean settlements, But what we should be doing is identifying those cases that are especially appropriate for public legal determination, and that we should focus on that. And I think that JR cases, many JR cases, are quintessential examples of that category of case. Thank you.
Thank you, Hazel. When she says she has not much to say, she did have quite a lot to say.
I talked too long, even so I keep talking.
But while I listen to her, it reminds me of the Congreman case, which we have discussed a few times today. And that case, it is quite possible to challenge the decisions of the Director of Social Welfare refusing to grant social welfare on the traditional Wednesday unreasonable grounds. And the legal team from day one decided not to pursue that challenge, so as to leave no way out for the government or the judiciary, and so that the issue of the right to social welfare will be squarely before the court, that the court has to decide. So much about mediation, in a way, you try to cut out all the possible way out so that you can force the decisions. Well, we have a long day and we're running almost close to the time. I would feel bad not to allow one or two questions if there's anyone from the audience. Yes, Sue?
Thank you. Just a very quick comment. As you all know, I'm Sue Cham. I run the Financial Dispute Resolution Center, so I deal with mediation every day. Well, first of all, I agree with Dame Hazel. Mediation is really not snake oil. You know, it's not a panacea for all cures, you know, for use for all cases. And I think judicial review is really special. It's about rights. Mediation is really interest-based most of the time. And there are appropriate cases to use mediation, and there are a lot of not appropriate cases to use mediation. So I do totally agree with a lot of the cases you've shown. My experience in New Zealand when I was with the Human Rights Commission is that when we changed to the mediation model, we did use the rights-based mediation model that you talked about. In fact, a lot of the statutory bodies that came, when they had a settlement, they actually won the publicity. They urged us to put it into case studies. But when we started at that time, the government had exempted itself from the Human Rights Act. So therefore, you know, you can't be dealing with judicial review cases mainly because it was only based, it was only for if you had a claim against a company, so it was just private rights. But then with the new century, it was decided that government wouldn't be exempt from the Human Rights Act. So that's when there was the possibility to take government departments to account. And therefore the kind of, school cases, for example, where the Ministry of Education was the respondent, for example, that sort of complaints about expelling disabled kids from school, kids with ADHD. So I think a lot of those cases were settled really well. And the schools and the Ministry of Education were very happy with the results. And even though mediation is confidential, but if everybody agrees that they want to make a case study out of it, sure, because it goes by consent. So you're still able to do the public education side about telling other schools as a precedent you're not supposed to discriminate because the child has got ADHD or things like that. So I guess what I'm trying to say is that in specific cases, it's a very useful way to get everybody's views, sit around a round table, and get it sorted out that way instead of going through the courts. So the response we got back in terms of feedback was that they were very positive about it, because for a lot of them, it was, for the parents especially, it was a time to just, spill the beans and, get it off the chest, the frustration of having a child that's disabled and not being able to be in any school, that sort of thing. And it's sort of quite healing for them. That's the feedback I've got. But of course, in Hong Kong, you can ask a practitioner. I don't think, Mark, that we actually use mediation in JR cases. Just not at all, isn't it? Not in Hong Kong. And also because we don't have the protective cause orders here. Whereas, like in New Zealand, mediation at the Human Rights Commission is free. So it's a public service, it's paid for by taxpayers. Because all you want is to, really work for the resolution of the case. And when government is actually subject to the Human Rights Act, it's a party to the dispute. So they can't run away from responsibilities. They have to meet all the requirements in the Human Rights Act. So I think that's the step where New Zealand is at. But thank you very much.
Yes, Lord Carnwath.
Just a short footnote to what Alex was saying about the interesting development of the judiciary, commenting on government policy. I mean, he's quite right. It's traced back to the Constitutional Reform Act of 2005, which got rid of the Lord Chancellor. But part of the new settlement was to impose a duty on the Lord Chief Justice and indeed the senior president of tribunals to represent the views of the judiciary to Parliament. And so there's in a way a sort of statutory basis for it. And you didn't mention this, but actually that the Supreme Court were not parties to that consultation. Not that we disagreed with what they were saying, but simply that it was thought preferable that we as a sort of Supreme Court should stay slightly apart from it.
Thank you, Lord Carnwath, for that. Well, I got quite a number of questions for Alex. I think I can reserve it for another occasions. I think with comment of Lord Carnwath, it might be a time to bring this conference to an end. Although we have a long day, I'm sure you all agree with me that this is a very interesting conference. The speakers has brought a lot for us to reflect upon. And the whole theme of today, in a way, is the judicial review in a changing society. And underlying, we start from the beginning with Lord Carnwath, explorations of when there's unreasonableness, rationality, proportionality, and throughout the day, I think the main theme, in a way, which we can't run away when we consider judicial review in the wider context, is what exactly is the scope of the judiciary, how far it could go, whether in policy making or unmaking, whether in national security or decision to prosecute, and we can't avoid this issue. At some point, demarcation has to be made, and this demarcation is never static. It always changes with the wider context where judicial review is placed. And at the same time, we've also heard how in Hong Kong, of the three branches of government, judiciary is held in high respect, and sometimes unrealistic expectation has been made. Partly judicial review is seen to providing an answer to the deficit of the democratic process, but then whether that is a good thing or not remains to be seen. But when unrealistic expectation is put on the court, particularly to resolve difficult political issues, and at some point when the judiciary cannot deliver what the public wants it to deliver, what does that mean? These are issues which probably we need to reflect further. And with that remark, I'd like to thank all the speakers again. The quality of a conference is only as good as its speakers, and we have a wonderful and excellent panel of speakers today. So let's thank all of them again with another round of applause. And I would like to thank all of you for participating and staying with us until these very late hours. For the guests who are going to dinner tonight, just a short announcement. We have a coach arranged for taking all of us to the dinner tonight. The coach will be waiting for us at 17:50. So 10 minutes to 6 at the roundabout downstairs. Either we can wait it here, or if you want to stretch your legs, we'll meet at downstairs at the roundabout, just at the bottom of this building on ground floor. Thank you, everyone, again. Thank you. Take care.